Well, we don't have chocolate, but, I'm a little biased. I think we have something better. We have 5 leading legal experts to talk about hot topics in legal. So stay here and then get your chocolate after. So today, what we're going to talk about is the key hot topics in legal for 2019. For those of you who don't know me, my name is Amanda Perot. I head the legal committee for DMLA. I'm also the head of the legal team for Adobe Stock. As I said, we've got an excellent panel here today, starting from the one closest to me is Paul Reinitz, who is Director of Copyright Compliance at Getty Images. On his left is Sejal Patel Rishborg, who is AGC IP and Litigation at Shutterstock. I feel like I don't have to announce Nancy, but I am going to do a little bragging. I found out in preparing for these intros that she won a 2020 Lawyer of the Year in Trademark Law. She'll probably never say it, so congratulations. So, yes. And next to her is Margaret Vinson, who I've learned also used to be in legal, is now leaving our profession to move to a different role in Stocksy, but is still on the panel. And Dan Pollock, who works for a boutique IP firm based in Canada. So before we dive into topics, we're going to do the important legal disclaimer. Even though you have 6 lawyers here, what we're presenting today is just general legal guidance, and it doesn't address any specific matters. The application and impact of various laws vary based on where you're based. So the information shared today should not be used as a substitute for your own legal counsel. So please talk to your own lawyer. And also the opinions expressed here today are not those of the companies we work for or necessarily DMLA. So now that the legal disclaimer is finished, we'll get to the more interesting part. So while this industry has always been extremely interesting and a lot of active areas with litigation, new cases and new laws, when we were talking about the panel topics today, it's actually even more exciting and also a lot of gray areas. There are a lot of new laws like GDPR or the EU Copyright Directive, and we're not sure what's going to happen with them. Also, there's this whole area of AI and machine learning and how that impacts the content industry. So today we're going to be focusing on kind of the 5 things that keep us up at night and make us think a lot as part of our jobs. Privacy law, copyright in the age of AI, EU Copyright Directive, copyright enforcement, and the legislative update. We're going to hold questions till lunch because we're running a little late and most of us will be available at lunch, so please come find us. So to start with our first topic, last year, Sejal from Shutterstock gave a very helpful overview of GDPR, and she's continuing that conversation from last year with more insights and lessons learned as we're about a year into the GDPR implementation.
Hi, so I'd like to begin my discussion by... That's helpful. I'd like to begin my discussion about privacy law by emphasizing that, I think there's a little bit of a misconception about what parties' privacy laws are sort of aimed at. I think there's this misconception that these laws are sort of more intended for the bigger companies of the world, the Googles and the Facebooks. But really, if you take a step back and take a look at what's happening around the world globally with privacy legislation, you begin to see a very different picture. So for those of you who are not familiar, in the EU, the GDPR was passed in 2016, and that was probably the first major expansive legislation that gave a lot more rights to individuals and how they're able to control and use their own personal information and how companies that they're giving that information to can use that information. So that passed in 2016, and what's happened since then is very telling of a bigger global move towards giving individuals more rights over their personally identifiable information. In 2017, China and India followed suit. In 2018, Brazil followed suit. For those of us in this room, I think most importantly, California became the first state in the US to pass a privacy law. And then in 2019, which brings us to today, Australia amended their privacy law, and 15 other states in the US have also been active in drafting legislation, and they're at various points in drafting privacy laws related to data protection. So here's a visual of what that sort of looks like when you're looking at privacy laws in application to the whole globe. Almost 60% of the countries in the world have some sort of data protection or privacy legislation, with an additional 10% with pending legislation. So last year, I focused a lot on GDPR and how the EU law would affect all of us in this room, especially if you have customers in those countries or maybe photographers in those countries. But what we're seeing now is that these laws are being adopted all over the world. And so it's becoming increasingly likely that these will affect how we conduct business. So every country that's adopted one of these laws has done so in different ways, but there's a few provisions that are common to all of these, or mostly applicable to all of these legislations. And one of them is the right to notice and transparency. There's this idea that if something is happening with your data, you should be able to know what that is. That companies should be giving notice if something's happening. Individuals are now given an increased right to limit and control the usage of their data. There's the right to be forgotten. If you want to have all of your information completely off of a platform, you should be given the right to do that, and a lot of these laws allow for that. The right to opt out, the right to data portability, which I'll get into in a second because it really impacts us as businesses that license content. And then, of course, the right to correct and remove data from various databases. So as an individual, I think personally these rights are great. As somebody who signed up for Facebook in college, I'm very grateful that I can now go into my account and delete everything, and it will truly be deleted, mostly relating to fashion choices, nothing terrible. And if you go into Facebook, you can actually see that there's a place for you to download all of your data, like anything that you've ever posted or people have posted about you. It's really interesting. But as a business or as a person who is in a role where I have to look at risk mitigation for my business, I'm very conscious of the fact that this now means that we need to be looking at how we allow these rights to be enforced by the individuals whom the information is about. So GDPR has now been in implementation for a little bit over a year, and I've put up some stats about sort of what that enforcement looks like a year later. And the numbers that sort of jump out at me is that there have been close to 300,000 complaints to regulators. There's been more than 400 cross-border cases and 89,000 data breach notifications, as well as 56 million euros paid out in fines. And I think the reason that these numbers are really important to look at is because in Europe, if an individual wants to file a complaint against you, they file a complaint with what's called a DPA, which is an agency that takes a look at the complaint. You're notified as the business that there's been a complaint against you. You don't necessarily know what that complaint is. And then you start to get into, well, this person that filed this complaint was in France, but my business is only in Germany, so which regulatory authority should be looking at this case, and that incurs a lot of legal fees. So we are seeing these numbers in Europe right now, but as I showed in the map earlier, these laws are becoming very expansive in terms of global reach, and so it's something that as a business where these laws might apply, it's something to be very conscious of. So I think the big question is, how does this apply to this room? How, are content licensors really subject to these privacy laws that really in the news we're hearing about more in relation to Google and Facebook and some of the other bigger companies? And there's a few things to sort of look at, and it'll depend on the nature of your own business. But the first is, are you taking information that could identify an individual? So some of this information is really obvious, like you take somebody's name, photographer's name, or somebody who's depicted in an image, you have their name, their address, their email address, things like that. But in our specific space, we have photographs of people, whether that's because we're licensing them commercially and we have model releases on file for them, or whether they're depicted in editorial content, we actually are holding likely a lot of personal data, which makes many of us subject to these regulations. The second thing to look at is the individual that you're transacting with, whether it's a photographer or somebody who's supplying content to you, are they residing in a state, if you're in the US, or a country where privacy law applies? And also, where are you located? Because depending on the answers to those questions, different laws may apply. So one example is if an individual, for example, a model, resides in the EU, then the GDPR would apply to you if you're taking their personal information and doing something with it. If a content licensor is located in California, CCPA, which is the California privacy law, could apply. Lastly, you should take a look at whether you're covered by any exemptions. For example, if you're a licensor in California, you're actually only subject to the privacy law in California if you're meeting a certain revenue requirement. So I think that law is if you're making gross revenues of $25 million or more, or if you're earning 50% or more of your revenues from selling data, that would apply to you. So those are sort of the three things to look at to see if any of these laws actually apply. So lastly, I've come up with this very general, high-level checklist for considerations to think about when it comes to privacy law. So the first is take a look at the data that you're taking in. And you might think, oh, I just have like these emails with some names and, you know, whatever information, it's not a big deal. But actually, if you're taking it, you now have obligations related to that information. A few years ago, Shutterstock was taking, for example, IDs because we wanted to verify that the people who are giving us content were real people and, you know, to deter fraud and things like that. And then we realized, well, do we really need all of that data? Do we need that to sit somewhere? Because we're not really doing anything with it. So really taking a look at the purpose of any data that you have on file is really important, because once you have that data, then you have obligations that are attendant to having that data. The second consideration is determine whether the usage is exempt. There's some exemptions in the various laws where they say, you know, you have this personal information, but you need that in order to fulfill contractual obligations. So you might be covered by that, and that's something to take a look at. The third consideration is either update your privacy policies, or if you don't have one on your website, strongly consider creating one. There's a really good template for one on the DMLA website, and it's something that you should definitely take a look at, because one of the requirements for taking this data in and using it is getting consent from the end subject. The fourth consideration is looking at your technical ability to handle data requests. So if somebody writes into you, let's say a model writes in and they say, I don't want you to be licensing my images, get them off of your site, like I want them completely gone. You have to make sure that you're able to do that. Where are your images sitting? Are they stored in a way that's easy for you to figure out where it sits and to remove them and completely remove them in the way that's being requested?
Do you have to do that, or would there be an exemption? Because there's a business reason to keep model releases, because you need them for licensing.
Yeah, and you're right, and it depends on which law
You probably
applies.
gave everyone a heart attack here.
If you're in an area where a privacy law that requires that, that's something that you should ensure. But really, I think the underlying message is taking a look at your technical abilities for handling any of these requests if the laws apply to you. And then lastly, determine a process for breach reporting. So, you know, if your business is not of a certain size, you might not have an obligation to let people know that their data has been breached. But especially with laws like the GDPR, there is a 72-hour notification period once you discover a breach that you have to let the people whose data has been breached, to let them know that it's happened. If you find that out on a Friday, and, you know, or if that happens on a Friday, you're gone for the weekend, like by Monday, Tuesday, you need to send out a breach notification. You're going to be in trouble if there hasn't been some discussion of how to, you know, go about and let people know if that's happened.
And I think the other thing I'd want to add is read articles about this. I mean, it's a new law. We don't know how it's going to be applied to this industry, so these are great, but what we're all doing is looking to see who's getting fined, who's having cases brought against them, and what are the judgments, because that's really going to inform how this plays out. So this is an excellent checklist, plus seeing what's happening in the world.
And just to add to that, the GDPR fines, they've fined a total of 56 million euro. I think it's actually 62. I read an updated number. And the majority of that is from an action against Google. So right now we're in the world where it's sort of maybe the bigger players or where regulatory agencies are focusing on, but over time, as we're seeing the map and in the increase in legislation, it's going to be something that is something that we all need to worry about or at least consider.
Great. So continuing on to yet another newish area of law, we're going to dive into AI and machine learning, which is another area we're not sure what's going to happen, what technology is going to develop, what laws are going to result from it, and also how it's going to impact the content industry. So Paul's going to lead us through this discussion.
Great, thank you, Amanda, and thanks for asking me to join this panel. One slight correction: my title is no longer.
I apologize.
I don't do copyright compliance anymore, and I don't really care so much, but I now are handling advocacy and legal operations, which I think are actually pretty relevant to this topic because it's something that is going to impact and certainly has the potential to disrupt this entire industry. And I want to be able to interface with anyone who's interested in learning more or talking or exploring these issues going forward.
Next slide.
So copyright in the age of AI. I think I'm not going to get into sort of a technical discussion here. I'm not the right person to do that. But the takeaway really is that the future is now. This stuff exists. So what you're looking at right here are not real images. Those are not real people. They do not exist. They were put together by a company out of Russia, sort of a startup called Generated Photos. You might have seen some articles about this a couple of weeks ago. They look pretty real. There's certainly the potential for those images to replace some of what we license. And so I think as an industry, we have to really start thinking about this because it's only getting better. These are only faces, but and most of this is handled by, I'm not going to go into the technology again, but by what's called GANs, or generative adversarial networks. And it's basically machine learning that is trained on, mostly it's going to be real images that exist, that are protected by copyright, and can output basically this. And so this is in front of us, and it's something that we need to now to rethink the interaction between computers, the creative process, and copyright. And it is something that regulators are thinking about. And they're thinking about not necessarily in the context of our industry or the copyright context. They're thinking about deep fakes, and you've probably heard about them. But these are images or even videos that use AI to create, inauthentic content. A picture of the president or a video of the president saying something that never said. This is stuff that is really convincing, and governments across the globe are very concerned about this, and they are very interested in regulating. And I think from our industry perspective, there's a lot of potential for this, and I'll go into a little bit of why I think that. But we want to get our voice out there and make sure that it doesn't get sort of regulated out of existence. And now is really the time to voice that. So there are some clearly unresolved issues, and I don't think we're going to get resolution on these really anytime soon, but I think we need to sort of understand them. And some of the basics are, can copyright exist in synthetic content? This is a question that has been part of copyright for a very long time. If something's being created by a machine, does that meet the requirements for copyrightability? Another question, is permission needed from copyright owner before using an image in a training set? That is certainly up for debate, and I think from the perspective of our industry, we certainly want to protect our copyright, and we do not want our images to be used without permission. Along the same lines, are the synthetic images that are created from these models, can that be considered a derivative work? And should the underlying copyright holder have rights in that work or be entitled to some sort of remuneration? And then beyond copyright, what privacy issues are implicated? I mean, going through what Sejal just went through, there are certainly, there's biometric data that are in images of models. We as an industry have handled this well. We have releases that can give us rights and that we can commercially exploit. Can we use those same practices in the context of AI? And finally, should the law regulate the use of synthetic content? And if it is, what should those regulations look like? There can be regulations that stop sort of like the deep fakes, but they can also enable the productive and beneficial use of this technology. So going into sort of the copyright considerations, and I touched on this a little bit, but there are really two elements to consider. As I said before, in order to create this synthetic content, you need to actually have real images that the model is trained on. And so you need to think about what are the rights in that underlying training data. And then when synthetic content is actually created, are there any copyright that attaches to that? And what sort of factors do we need to look at? Is there some sort of human involvement? And if there is, who owns that copyright going forward? And then one other part of this too is how do we track and maintain consistency about what content is available? And so if training data is used, should there be a requirement for tracking what training data is used, what images are used? And currently, there really are no standards for that. A lot of this stuff is being handled in the academic sense, or by startup companies out of Russia that may not be thinking about these sorts of audit trails. So I think we want to also think about policies that can benefit the human creators that are behind the training data that are used here. And so I think there are a couple sort of policy things, and I don't think we've really articulated exactly what these policies are going to be, and I think that's something that we need to consider as an industry. But I think these are just some ideas that can throw out there. One of them is to explicitly recognize images as a unique category in the regulation of synthetic content. And I think that really that's sort of a protection against over-regulation. Let's not treat everything the same. There can be a vibrant market for the commercial exploitation of this stuff. Let's not close that off before it can even get started. I think another thing we want to make clear is that there needs to be prior authorization to include copyrighted content as training data. You should have to go get a license from the underlying copyright owner if you're going to train data. Where applicable, and it's not, I don't think it's always going to be the case. Like I said before, there has to be some sort of human involvement. But think about when we can introduce copyright protection for synthetic content. Otherwise, if there's no copyright for synthetic content, then obviously, the business model for licensing content sort of goes away, and you can have a huge amount of content that's not protected that anyone can use for any purpose, and then why would somebody come and license content if you can't really distinguish authentic content from synthetic content? And then finally, I think that we want to be able to think about applying the same principles of licensing in our traditional models. We've been doing this for a while now, and I think we have some really good policies and practices. For instance, being able to store model releases and have an understanding of what's editorial and what's commercial, and use all of the same understandings that are well established.
I think the last section you were going to touch on was privacy, kind of dovetailing from what Sejal said.
Yeah, exactly. And so beyond copyright, so we have real privacy considerations, and biometric data is in a photo. So or machines can look at photos and make real assumptions about that person. And when that person is then included in a training set, how can you deal with those privacy implications? Do you need to get consent ahead of time from those models before you even consider, say, selling your images to be used in a training set? So yeah, and I think that it needs to be clear that the burden to respect privacy rights should really rest on whoever is creating the synthetic work. That plays well into our industry because if you want to meet those obligations, come get your licenses from somebody who is a reputable distributor of content and has the rights. I think, as I said, privacy needs to be addressed through disclosure and consent, and we really want to promote the protection of privacy through responsible commercial practices. So some final thoughts on this. So I think as an industry, we can look at synthetic content as an opportunity. Yes, it is certainly disruptive, but we are really well placed to exploit this. As I said before, there can be positive or negative outcomes, and I think we need to be really careful. And I think that we can also give a voice to legislators to understand that there are productive, beneficial usage of synthetic content. And along those lines, if we want our voice to be taken seriously, we have to show the respect for copyright and privacy and those rights that I outlined.
So I know we're pressed for time, but my understanding is currently in the compendium, the Copyright Office compendium, there's a human author requirement for content, for copyrightability. And it's the same, there's similar in Canada as far as having that person, it has to be a person. So don't you think that the Copyright Act would actually have to be amended or
potentially? I think at some point, when cameras were created, that was considered a technology. Was it clear? Was there enough human involvement to be copyrightable. At the time, there was probably some question about that. We have no doubt about it now that there's enough human element, and I think that we need to explore that. Who is picking what actually is done by the synthetic content? There's potential for. I want a photo that has 3 people standing by a lake next to a mountain. Is that enough to if that's an idea and I'm using a machine to put it into a tangible form? Is that enough for copyright? Maybe. I don't know. We have to figure that out.
I want to make sure we hit our other 3 topics, even though we could talk a lot on each of these. So our next one is the EU Copyright Directive. This is another one where there's still a lot of open questions because it hasn't even been implemented in the States, but Margaret's going to give us a highlight on this.
Yeah, and we had a really great roundtable yesterday on the topic, and what I learned is there's no possible way to quickly cover everything here, so I will give you some of the basics just to give you some framework. So I like to start at the very beginning. So what is the EU Copyright Directive and why do we care? A directive essentially sets the framework and end goal, and then each member nation can implement in their own way. So obviously this means implementation across many different countries with various interests and histories, and you get that beautiful uncertainty that is our theme today. The directive is actually in force as of June 7th of this year, and there's a 2-year implementation period. So essentially in the next 2 years, we're gonna see how that plays out and what's changed and how each member nation implements. Why change the existing copyright law? Laws generally are old and slow and created long before there was digital technology. And as we've just seen, we have to continually assess how that law works with new technology. This directive is aiming to modernize and address those newer technologies and the resulting challenges from that. And why we care. If we're selling in an international space as international platforms, working with international artists, we will run into these things. We've mentioned GDPR. I always like to think of that as the day everyone got 1 million emails about updated privacy policies. But that's a good sort of lesson in how far the reach is. These things really do have an impact no matter where you are. Switch. These are the objectives that the EU set out. I'm going to change up things a little bit after talking yesterday. I've got a different idea, but these are the objectives that hopefully we reach. The reality, as I said, is everything is pretty much up in the air. And it's very likely that the outcomes will be varied regardless. You can skip the next slide. It looked better there than I thought it would, but I think we have better things to talk about. So just really quickly, the goals here are to balance the interests of the rights holders and the platforms. It's very simple if you look at it in this respect. So rights holders get reasonably paid for the work they're doing, increased understanding of how their work is used. The platforms get to use the work and make a profit from that use. Of course, it's never that simple in like real life and how things play out, but that's the goal. We are seeing a shift in liability towards those platforms, which I'll get into in a second. There are a number of articles in this. They address all kinds of different topics. There's a link tax that's super relevant for news publishers. There's some public domain discussions, and as we talked about yesterday in the roundtable, whether it's a change in the public domain rules or not. That's the level of debate we're at. Renegotiation of remuneration if content becomes widely used. There's a lot in this directive that will impact our worlds. So I want to focus mostly on Article 17 right now because I think that will be, that's probably the most directly impactful piece. So currently, most in the states, and in a lot of ways, so the DMCA is our copyright law. And it has a safe harbor provision, which essentially we issue those DMCA notices, and the service provider takes down the content, and that's that. Essentially, what the EU is doing is shifting that. Notice and takedown will be insufficient. Platforms will be liable for that use, that inappropriate use, unless they have made best efforts to obtain authorization for the use, made best efforts to ensure unavailability of those works, expeditiously disable access to the works, and make best efforts to prevent future use of those works. Right now, you take down the content, it can get popped back up somewhere else, no problem. This adds in the obligation to make best efforts. In my research for today, my favorite sentence I found is talking about all this wiggle room of what best efforts actually means. And I'm just going to read it to you because it's classic. There's a real prospect of more discussion and potential litigation around what exactly constitutes best efforts, which in itself appears to be an American-inspired term. So there you go. And we know we have terms like this in existence in law now. They get defined through case law and historical development, and that's something we'll need to watch. Let's see. I think, I'm trying to juggle all this new information I have. I'll get out the really important piece, which don't worry, your memes are safe. And then, actually, Paul, you had some really great insights on how our agencies and industry may qualify as content sharing providers under this article.
Yeah.
Did you want to speak to that?
Yeah, I mean, I think just quickly, if you rely on the DMCA now, and we all have lots of content, and we may not know everything about that content, and we can rely on, if it's user-generated, we can rely on the DMCA now to take it down. This has the potential to apply to us as well. And so we may need to use technology to keep content that has been reported to us from coming back up. I think it's a little unclear, like all of this, what that's going to be, but we should be thinking about how we can implement that technology. And as I said yesterday, it's very similar to the technology that we use now for copyright compliance purposes. Image matching exists, and it's something that we need to probably think about how we can implement for our collections as well.
Yeah, definitely. There's a ton of information in this directive. There's a ton we could talk about. We ran through our hour yesterday much faster than I expected, and I still had pages of questions. Essentially, I think the takeaway for all of us here in this moment is that we need to watch. We're going to see a lot of changes and progression over the next 2 years as this is implemented. I am quite sure we'll be up here talking about it again in the future. But just to recognize that there is a lot of uncertainty and questions, and that the development of those answers is going to be impactful in our industry. And as Paul has pointed out, there's a lot of space for us as an industry to impact how that development happens. And I know that CPIC is working very closely on that and has some really wonderful ideas and a voice, and I know that Paul as well with Getty is involved in that. So there will be plenty of advocacy opportunities as we go forward, and a good space for us to make some good change.
Great. We've been talking a lot about theory and uncertainty, so we're going to turn to something that's a little more practical with Dan, who's going to talk about copyright enforcement, do's and don'ts. This may change based on everything we've talked about, but this is at least something more concrete than the theory we've been discussing.
All right, thank you, Amanda. 2 more topics to lunch, so there we go. I want to keep this very high level, and we had similar to the EU Copyright Directive, we had a panel yesterday talking about copyright enforcement and really more of a deep dive into it with a great panel. So this is really just some basic do's and don'ts in terms of doing copyright enforcement work. Okay, so basic one, copyright registration. You should definitely do it in the United States. You need it. You need to register before the infringement or within 3 months to recover statutory damages, and that's really the big hammer that you have, especially in the US. And there's going to be a panel later today if you want to learn more about copyright registration, so that's a great way to learn more about it. Understand your obligations. So you might have, and when I say you, I'm talking about a licensing agency. And you might have a distributor, for example, that has exclusive rights in a certain territory, including enforcement rights. So you have to be careful with that. You might have a distributor who licensed the content, and you want to make sure that you're not contacting someone who actually has a legitimate license to use that content. Chain of title, this is critical. So you need to have the assignment of copyright in writing. And so, or the exclusive right to license the content in order to have the authority to actually bring a claim. And, excuse me, I'm battling this cough. It's something that infringers will ask for. So you need to have it ready, and you need to be able to provide it, in particular their lawyers. They'll want to see that chain of title. The licensing model, rights managed, is pretty straightforward. It's a certain period of time for a certain usage. The fees are traditionally higher. Royalty-free, you really have to be careful because you may not know who the end user is for that content. Also, the fees might be really quite low, so you might approach it in a very different way than you would with a traditional rights managed type of license. And then look into the defendant. Looks can be, defendant I mean infringer, looks can be deceiving. So you can have a really slick looking website with a Park Avenue address, and you dig into it and you find, oh, it's actually a UPS store or a PO box. So Secretary of State websites are a great resource because they provide all of the corporate information, and you can see where they're registered and see their real address, because I've had a lot of cases, big, great looking cases, and it turns out the defendant is really in India. So there you go. Next slide. Yeah, kind of self-serving, but hire an expert, and especially if you don't really know much about this, definitely go to a copyright lawyer and someone who litigates as well. So you don't want to have this 2-step dance where you've hired a lawyer and then they go, oh, sorry, I can't file a claim. You want to get someone who can litigate the claim and listen to them, especially on damages and in different countries where it's not going to be the same as the US. And you want to get a sense of what is the claim worth in their view, what's realistic in terms of a recovery for that claim. So similar point, think about the demands that you're making in terms of what you're seeking. And I put Goldilocks because you obviously don't want it to be too low because you're not going to get any more than that. But you don't want it to be too high either. If you license it for $10, you're probably not going to ask for 10,000 unless it's really weird circumstances. So think about it carefully. Gather the evidence. Don't rely on your lawyer to do that. So get the screenshots, save them. Do it because it disappears. And especially in social media and the way images are used these days quickly, you want to save it. If you're enforcing in different countries, learn a little bit about the law there because there could be some different remedies available to you. For example, in some countries you have removal of rights management information. You have that in Canada, you have that in the US as well. In Canada and many European countries you have moral rights. I put a note about declaratory relief. So that's where the defendant can bring a preemptive lawsuit against you if you're threatening to sue them, so watch out for that. Pretty rare, but more common in the US than anywhere else probably. And whether you can recover attorney's fees if you litigate. So in Canada you can, for example. And then finally, alternative settlements. So this is something that comes up from time to time in my practice where an infringer will want sort of something unique, and I put quid pro quo because they might want to have like, oh, let's work together and do marketing for you, or I'll promote you, or something like that. I'm kind of loath to get into those, and so are most of my clients, but you never know. It might make sense for you. And future rights in particular, if you're taking the softer approach where you're interested, it's not, you don't license for high fees, but you want to potentially develop business with these people, you might want to grant future rights for the content. Okay, so there are two of our main sponsors for this amazing conference are enforcement services, and so you should speak with them and they can tell you all about their services and what they provide. I just want to go over from the perspective of you, the licensing agency, what to look for. I'm going to use the old quote, I'm going to date myself here, but an educated consumer is our best customer. Sims, the clothing store. So do your homework. Review the claims carefully. What I mean by that is if you're using a service, don't just say, oh, no license, pursue. Take a look at the claim and think about it, in terms of whether it's something you really want to pursue or not. Understand how their process works. So is it a two-step process where they have internal enforcement and then escalation to a lawyer, or do they just have legal partners in different countries? Read the contract, obviously, beyond just the royalty split in terms of how the process works. What are the settlement amounts? Think about that carefully because you want to give them flexibility, but you want to set parameters so they're not settling claims for far below what you expect in a settlement. Obvious points, but where do they work? Who do they work with? And there is work on your end. You're going to need to be responsive as far as providing things like artist agreements and documentation, potentially licensing fees for how much you license your content for. And it's important that it's a two-way street because if you wait too long to respond, the claim will get stale. And finally, make sure they're asking you the right questions. So they're asking you, for example, are your works registered with the Copyright Office? What kind of fees do you charge? What kind of licensing model do you use? Rights managed, royalty free, and so on. And then the final point is have a thick skin. If you're doing this kind of work, you will be called names. People will say things about you. So it's something you have to be prepared for. Okay, next one. And then, yeah, just quickly, it's really the opposite of the things that you want to do. Don't do the opposite. It's a related point to what I was talking about before, but sometimes it really is better to just walk away. And you can't sue everybody. You can't pursue every claim. And you want to be careful sometimes about the optics of certain claims, realizing that there could be a significant blowback and it could result in really bad PR for you if you pursue this claim. And all it takes is one claim like that where it really can undermine all of your enforcement efforts. And be flexible about it, and it's kind of related to the points before. But in terms of your expectations, again, talk to your legal partners, talk to whoever you're working with in terms of what you can expect from it and what kind of settlements you can get. Don't do it on your own, definitely, unless you really know what you're doing. If you do, that's great. But otherwise, work with partners who know what they're doing in this space. The last point is kind of a minor point, but again, and it's related. Don't just use kind of cookie cutter settlement agreements and releases because what you find on the internet is probably very inapplicable to the image licensing world. And then my final point is really that this can be a real source of revenue for you, and it can really, and it shows your artists, your contributors, that you have their back, and that you're willing to fight for them. But there are risks, and you have to do it the right way, and it involves work on your end as well. And that's it.
Great. So our last topic is Nancy and the legislative update, and I hate to rush, but we have about 10 minutes.
All right. So I stand between you and lunch, so here goes. I think it's actually good that this legislative update is last, because in a way, this shows what a trade association can do and how it can be effective to be the voice of everyone in the room, from the largest agencies to the smaller boutique groups, because DMLA has been working with a collective of the Copyright Alliance as well as many other visual artists associations to really affect change. And this is like almost exciting because change happens very slowly and we're getting really close, so I have some exciting news on some of this. But you know, copyright, as we've noticed, was our last major update of the law was 1976, and a lot of things have happened since then. We've had the internet, now we have AI, and there's a lot of areas where it still works and a lot of areas where you know, there's room for improvement and it doesn't quite make any sense. And so Congress over the last number of years, ever since former Registrar Maria Pallanti came up with the concept of the next great Copyright Act, has really looked at modernization and is holding hearings and is really looking to see where things can function better in terms of many aspects, in terms of technology, making it easier to register online, also getting the registration process through much more quickly, and to look to see, you know, where things need to be changed. Everyone in the visual arts has always complained about the definition of publication and not understanding whether a work is published or not, and you know, can we help affect change in that area? So we're on these committees, and I literally have 2 calls a week between the Copyright Alliance as well as this Visual Arts Association, so we all stay on the same page, because many other industries, like the technology industries or motion picture industries, they have a lot of weight and they have a lot of money for lobbying, but it's really only as we work together, where we have a voice, will we be effective in working together. And so that has, I think often, maybe we should give credit to Kathy Aaron. She was the first one to put this group together a number of years ago, and it's really been much more effective. So now for the exciting part, let's move to the CASE Act, Copyright Small Claims. We're getting to the finish line. It is so exciting. This summer, the Senate Judiciary Committee passed the CASE Act, which was initially drafted by the Copyright Office through having reports and listening to all the stakeholders in the room. It's been slightly amended, and there's a bill that Jeffries and Collins has in the House, and it's really almost an identical bill in the Senate. Then the House Judiciary Committee passed the bill this September on 9/10. I don't know if you don't know how legislation works in the US, but there's committees within both the House and the Senate, and first a bill goes through the committee and then it goes on the floor. Well, Tuesday, after I submitted my slides, the House of Representatives took the bill to the floor. It wasn't a voice call, but they did have a vote, and it was overwhelming. It was 410 yes and only 6 nays, that's like bipartisan. That's like awesome. That's amazing. And now the Senate vote is next, and we're hoping that it happens really soon, because as you can see, there's some distractions going on in the House and Senate these days, and what happens if it doesn't get voted on before the end of the year, you have to start from scratch next year. That's how things work. So every year is a separate year. So last year, the bill was introduced in the House and went through for discussion and never got voted on, so then they start over. So we don't want them to start over. We want them to save a little bit of time in between everything else to get these done. Now, on the other aspect that DMLA and I look at is what's going on in the states. Copyright is federal, so we need to deal with the federal government. But every state has laws that affect how images are licensed, primarily with right of privacy and right of publicity. And that's probably very simply, you know, what you can do with pictures that have recognizable people in them. And New York has always had a very narrow right of privacy. When you die, your rights die, and it was very publisher-friendly, very, you know, I would say First Amendment friendly. Well, for years, the Screen Actor Guild has been trying their damnedest to make sure that we're much more like California, where, being more of a celebrity-driven state, that right of publicity and privacy is a property right. And when you die, it gets transferred on for 70 years. And instead of saying everything is, you can do anything with it except what's sort of protected by the First Amendment, it says you can't do anything that's commercial without permission, and here's a list of all these things that you can do. And that list was written in the 1980s and is very out of date. So we're trying to make sure that if New York has to have some kind of right of publicity bill, that it's a bill that looks to the future, that doesn't have restrictions on licensing, which was missing from the California law and has caused a number of class action suits in California. We also want to make sure that there isn't anything that interferes with the type of expressive licenses that are used. And the Screen Actors Guild, as Paul was talking about, is very concerned with deep fakes, not about politicians making false things, but there's a lot of porn videos that they put celebrity heads on, and so that's a big concern. The other big concern of the Screen Actors Guild is digital avatars, which they don't want to have, instead of the actor hired, an avatar hired. But that's an issue because that's written so broadly, like what's a digital avatar? Is it animation? Is it an illustration that moves? And what happens after someone dies and you want to do a documentary? So there's all these issues, and I'm part of a media law committee that's really focused on trying to make sure that if something has to go through, which the state says they want to, we stop something end of June. It always happens the last day of June before the legislators like go home for the summer, that they try to cram a bill down. And so what we're trying to do is have restrictions on the postmortem rights, limit the bill to anyone who's domiciled in New York, so everyone in the world doesn't come to New York and try to take advantage of it. Try to keep the digital avatars to living actors so it doesn't affect storytelling after people die, because if our customers can't use the pictures, we can't sell them. And, you know, try to make sure that all the exemptions that New York has always had under common law remain, and that licensing doesn't become a commercial act and we have to defend our system.
And Nancy, I think given time, is there one
and
case you want to highlight, or do you want to just...
The other issue is there's, of course, with a lot of litigation, because there's been a lot more in the fair use area, and maybe just a couple minutes to explain why fair use is always complicated. Okay, so we have two well-known artists. One is a well-known music artist, Lynn Goldsmith, and the other is Andy Warhol. Well, in the 80s, she granted Vanity Fair a license to have her work used as art reference. So Andy Warhol made a whole series of works. In 1984, Vanity Fair republished these works after Prince, and it's of the music star Prince. So when Prince dies, Vanity Fair republishes a lot of these, and somehow, I guess Lynn Goldsmith didn't know that these were created earlier. And you're talking about declaratory acts, and so she must have made a demand on the estate. The state sued back, which is the declaratory judgment, asking a court to say this is not copyright infringement, but this is fair use. And the initial court decision was that it was fair use, and that even though this series was commercial, that there was added value to the public through the advancement of the visual arts. The work was, the magic word, transformative, and the series removed, this is interesting, most of the protectable elements. So if you looked at it, they're really saying that if you take away the way that Andy Warhol did this graphic design, what's left isn't much of the photo, but really just Prince's identity. And so I believe she may be appealing that, but so far we have that did fall on the side of fair use. And then what did not fall on the other side of fair use is in the political arena. The poor Pepe the Frog was being used by a lot of far-right media groups, and Pepe had enough, and he sued, and the court said, yes, no matter how popular a character or it becomes, even if you become a meme, you still have a right to protect your copyright, and the court said this was not fair use. But fair use is really tricky, and you have to, as Dan said, you have to pick and choose your battles. And so in this case, there was a screenshot of a photographer's bike photo, a New York Post article, on its blog, and it was cropped and only showed the headlines, and it gave the photo credit. And the courts are kind of getting fed up with being sort of swamped with so many copyright cases right now. And when they see things that they don't feel is fair, they don't always maybe come out on the right side of fair use because they just don't like that this case was brought. So that's something that Paul mentioned that really is a consideration, to pick your battles, because the court did say that this use in the Post was fair use. But then we have the last one I'll give as an example, Auto versus Hearst Communication. Everyone knows as the Donald Trump wedding crasher photo, where, I guess an advantage of, having your wedding at a Trump property is you may get an uninvited guest. And a guest took a photo and just sent it to another guest. Well, this guest then essentially syndicated his picture. So Hearst Publication wrote an article about how Trump came to this wedding, and the issue was, well, is that fair use, because it's newsworthy, or is it just illustrating the story? The court ended up saying that it was not fair use, but they didn't give very many damages. This was not a professional photographer, it was just someone with the iPhone at the wedding, and they only got $750. So again, sort of an example of what, the highlights of some of the interesting cases that are circulating right now.
Wow, that is fair use in 4 minutes.